the functioning of the WTO, it will be run, of TiSA, it will be run by a committee of the parties, so it's not going to be institutionalized like the WTO or even like NAFTA. Decisions will be made by consensus, which means in theory small countries can look after their interests, but in practice big countries can veto if they don't get what they want. Provisions to review the operation of the agreement as necessary. So not specific times for reviews, but when by consensus they agree it is necessary. Rules for deciding whether others can join, known as accession, which I'm going to look at again a bit shortly, and discussions of what they call the multilateralization of TiSA, which means its insertion into the WTO. So the functioning of the committee is basically to oversee those processes. The disputes process, remember, and there's been some confusion here, that TiSA is only enforceable by states. Right? It doesn't confer direct rights on corporations that the corporations can enforce in the way that, say, the investment chapters of agreements or bilateral investment treaties do. A TiSA party can challenge a breach of the actual text or something Sanya mentioned yesterday, actions that they say nullify or impair the benefits that they expected to get from TiSA, even when there is not an explicit breach of the rules. And that exists in the WTO as well. The same dispute cannot be brought under TiSA and the WTO, so you would have to choose which. Can't be brought under TiSA and an FTA between the parties. Right? So we have what is called a fork in the road, where you have to choose which path you're going to take. There is no guarantee that the WTO case law jurisprudence, which isn't even binding inside the WTO, but is influential when you are making arguments, will apply in TiSA, because of course even some of the similar rules to TiSA may be different. But in particular, there's a whole lot of new rules as well. So if you were relying on the general exception, for example, for something you did under the e-commerce, a dispute under the e-commerce annex, the interpretation of the general exception may in fact be a bit different in the context of that. Undoubtedly, if you were a lawyer arguing such a case, the approach you would take would depend on which side you were on and which argument served your client's interests better, given that lawyers are for hire. This is incredibly important. At present, it appears that if there is a breach, if your government is found to have breached the country's obligations under TiSA, the penalty is not a fine, right? And it's not like the investment disputes where there is an award of money. Yeah? The penalty is by the logic of putting the deal back into balance, right? You have breached our deal. To bring it back into balance, you must either drop the measure that has breached, or you must make equivalent concessions to the value of the damage you have done to the deal. Right? Now, in relation to services, it may mean that there's been a breach in relation to education services, but there is a a compensatory adjustment that is awarded on telecoms or on tourism or on another services sector, which means that other sector is going to squeal because it's paying the penalty for a benefit that another sector has received. So in a political sense, this is how the politics of the disputes process domestically may work. But more than that, they are proposing that if you are found in breach of a TiSA rule, the other country can impose compensatory sanctions on your non-services activities, your agriculture, your goods, possibly your IP. And boy, are they going to squeal. And this is quite extraordinary. You have an agreement on services where the penalties can be against another of your export activities. And I think that's a really important, we need to think about how to use that. And there is no appeal system that has been agreed. WTO has, of course, an appeal system. And sometimes it does overturn what a panel has done. And it's a standing body. There is no proposal as yet in TiSA for there to be an appeal body. Which means if you have a decision that is awful, there is nothing you can do about it. Let me just finish the rest of this before we have questions. So the dispute process that they are proposing, first step would be to seek consultations to try to resolve the issue. If it's unresolved, the complaining party can proceed either to a dispute or to mediation, and that's new. So it's an attempt to resolve matters without there being the meltdown and expense of a dispute. But from what I can see, you can't choose both. You have to choose one or the other. The judges in the disputes will be trade experts from a roster. Right? A list drawn up by the parties. The parties can nominate X number of people to this roster or list. The only time there is a requirement to have experts is when there is a dispute involving financial services. They are suggesting, or they are saying, there would be a code of conduct for the arbitrators, but there is no code of conduct there. We've had the same in the TPP, and no one, I mean, you're told there will be one, but you can't actually assess whether it's any use. Other TiSA parties may be allowed to make submissions, which is common in the WTO as well, not only because they may be interested in with the same complaint, but also there may be an interpretation of rules that are important to them, and they want to make some submissions on what the interpretation would be of those rules. There is no right for non-TiSA parties, such as either the corporations or civil society, to make submissions in the form of what's often called amicus curiae briefs. However, the dispute panel, and this is an advance on some earlier agreements, the dispute panel must accept those amicus briefs or evidence that is within the boundaries of the dispute. So that can be very narrowly interpreted. Hearings will be public, which is another of the concessions that's been being made to these processes and the critique of the processes. but some documents can be kept confidential. And as we find in the investment disputes, that is very often the most important documents. So the disputes process replicates to some extent the WTO processes, but it's much thinner. Right? No appeal system in particular, and this rather extraordinary cross-sanction approach in terms of penalties. Okay?